To the Center for Migration and Refugee Studies monthly seminar series. I'm Usha Natarajan. I'm Associate Director at the Center. I'm a Professor of International Law, specializing in migration and refugee law. Today's seminar is delivered, and we're very happy to have with us here Tarek Badawi. Thank you, Tarek. And Tarek's going to talk to us about the Memorandum of Understanding between Egypt and UNHCR, problems and recommendations. Tarek is a licensed solicitor and barrister in Ontario, Canada. He's an attorney of law specializing in international law at Shahid Law in Cairo. He has extensive experience handling immigration and refugee cases both in Egypt and in Canada, and he's a former programs director at the African and Middle East Refugee Assistance AMERA in Cairo. Tarek, the topic that Tarek's going to talk to us about today is not only of extreme relevance to those working on migration and refugee law in Egypt and in the region, but broadly very, very relevant for the challenges that international refugee law and international refugee institutions face when operating in the global south, in developing countries in the third world. So thank you, Tarek, for talking this through with us, and I hope that in discussion time we can deal with this problem both in its local and global context.
Thank you, Usha. First of all, I'm very pleased to be here. The last time I was here to speak was in 2006, so it was about 9 years ago. So I feel I'm back at home where I belong. And I remember specifically what the presentation was about. I spoke about citizenship law in Egypt and the rights of non-Egyptians to various things, including property ownership and also naturalization and means of becoming or applying for Egyptian citizenship. So I remember the presentation very well. I just can't believe it's been 9 years already. I just wanted to give you a very brief background or overview of my practical experience in this case, just as a small introduction to the presentation. I worked as an advocate for refugee rights between 2003 and 2006, early 2007 at AMERA. I was the programs director for about a year and a half before I moved to working a bit as an independent consultant for various organizations. So I did wear in the period until 2010. So between 2006 and 2010 I wore two hats. The first one was that of the advocate. The second one was that, and I don't want to use the expression of the more objective person, but I was in a position where I could look at the refugee problem from a different angle. That of an observer and commentator on certain things relating to refugee rights, mainly under Egyptian law. And it's in the latter period that I had the chance to sit and think a bit about the former relationship that existed between Egypt and UNHCR, which was the foundation for everything that followed as of 1954 until this very day. So the presentation that I'm giving today is focusing mainly on events that took place between 2003 and 2010. So lots of things happen after that, but by analogy I believe we can apply or consider some of the things that were raised today and transplant them into the modern world or 2015 and see if they can still apply. I was lucky to have worked in Egypt during that period. Without undermining the atrocities that took place during that period, including certain events that happened in Egypt, for a practitioner, it was extremely educational because many events shaped refugee policy in Egypt during that period. And I'm going to name, or at least give 3 or 4 examples just so that you can get a sense of what happened. So there was a signature of the peace agreement between the Sudanese government and the SPLA, which eventually led to the independence of South Sudan, which majorly affected UNHCR's approach towards Sudanese refugees. there were also, or at least on this end of the border, we started feeling the problems in Darfur with a huge and massive flow of refugees from Darfur into Egypt, which again shaped UNHCR policy towards the refugees from this particular region in Sudan. And then towards the end of that period, there was, or we started feeling the arrival of Iraqis, which is a third or a different category of refugees, which was subject to another bundle of policies by the Egyptian government and UNHCR, Egyptian government of the time and UNHCR. And then there was also the signature of the Four Freedoms Agreement, which did, or at least should have, affected the way Sudanese refugees were treated in Egypt. And by treated, I mean legally. I'm not talking about incidents of racism and abuse. We all agree, just that we're all on the same page, that this is unacceptable and illegal. But I'm talking about certain legal treatments that should have been, or at least should have been considered in relation to applicants for asylum from Sudan. One thing I remember during that period is that there was an interesting relationship between the Egyptian government and UNHCR. There was shifting of responsibility, or to put it more simply, there was a blame game happening between both entities. So on one hand, UNHCR rightly indicated that certain responsibilities should have been taken care of by the Egyptian government, and the Egyptian government at the time would always respond by saying, well, we have an MOU with you, UNHCR, and based on the MOU, it is your responsibility to do 1, 2, 3, and 4. So I just decided to read the MOU more clearly, and I just realized that, for lack of a better word, it was a useless piece of paper. And I will explain why. It's just totally nonsensical, and it should be rewritten all over again, if not completely forgotten. And the reason I'm saying that is that because there were several events that took place since 1954, when the MOU was signed, until today, that should affect the way the Egyptian government interprets the convention and deals with refugees. And again, I'm going to give 3 or 4 examples just so that you can get a sense of what I'm talking about. So the first one is the decolonization of Africa and the emergence of a large number of new independent states led by despotic governments, which created massive flows of refugees across borders, including into Egypt. So that's one thing that, in a way, should affect the interpretation of the MOU, because at the time Egypt signed the MOU, the term refugees within the mandate of UNHCR was different. I'm still giving the historical context, so I'll move to... No, it was a bit earlier than 2003. So that's the first example, and including that, there was the independence of Sudan in 1956, which was not the case in 1954 when Egypt and UNHCR signed the government. At one point, Sudan, and I'm not talking about Palestinian refugees, but at one point, second to Palestinian refugees, the number of Sudanese refugees in Egypt was the highest. And then Egypt ratified the convention, the protocol, and the OAU Convention. So a new set of obligations were imposed on Egypt that did not exist back in 1954 when the MOU was signed, and should have affected the interpretation, as I will indicate later, the interpretation of the MOU. Egypt's ratification of major international human rights treaties, the International Covenant on Civil and Political Rights, Economic, Social, Cultural Rights, Convention Against Torture, CEDAW, Convention on the Rights of the Child. So there's a big number of conventions that were ratified by Egypt after 1954 that gave anyone, and I repeat, anyone present on Egyptian territory, regardless of the legality of that person's status, race, religion, nationality, certain rights that were not explicitly stated in previous instruments. So my contention is that the combination of all these events, coupled with the vague wording of the MOU, caused a lot of confusion regarding the responsibilities of the Egyptian government and UNHCR, which of course negatively affected refugees present on Egyptian territory, and as a result, the MOU, at least, should be redrafted to reflect the realities of modern-day asylum. So just briefly, I wanted to give a very brief background about MOUs in general that were drafted or entered into by UNHCR. So not all states have the tools to conduct refugee status determination. Egypt, I will argue against that at some point, but Egypt at some point in history did not have those tools, and for this reason it needed to enter into a Memorandum of Understanding with UNHCR so that UNHCR can do the job of the Egyptian government, basically. And we find that in many states, I mean, including, especially states that are not party, unlike Egypt, that are not party to the convention. So, for example, it did exist in Lebanon and Syria and various neighboring countries. To a large extent, we have that in the case of Turkey. Now, Turkey is a very special case because Turkey maintained a territorial limitation on asylum. It applies the classical old definition of the 51 Convention, where it only grants refugee status to refugees from Europe, which leaves UNHCR with the obligation to take care of about 99% of refugees in Turkey coming from Iran, Syria, and other non-European countries. So it is, I admit, a tremendous task for UNHCR. So to do that, there is usually a Memorandum of Understanding. Back in 2006, and I remember Mike Kagan, who's another programs director of EMIRA and a renowned academic in the field of refugee law, had, relying on UNHCR statistics, indicated that UNHCR conducts RSD in more than 60 states. I believe, I'm not sure if the number is still the same today. Perhaps anyone from UNHCR can confirm or say that I'm wrong. But the point is, it is the largest body responsible for RSD around the world, more than any other state. So basically, just to summarize this brief background, MOUs are a way that enables UNHCR to do the functions or perform the functions of the state on the territory of the state. Now, a big question is, what is the legal nature of MOUs? And just so you know, for this to be interactive, so please feel free to interrupt me and chip in and volunteer some information. So perhaps I can start with a question. What do you think is the legal nature of MOUs? Is it a binding document? Is it just a non-binding understanding between a state and a government? Can someone volunteer? I see someone nodding, so I really would like to hear your opinion. If you don't feel any pressure, like don't. Okay.
And the second option that you said is not a binding instrument that would make, that would basically force Egypt to agree on.
Okay, so it is non-binding. Does anyone disagree other than me? Great. Okay. I will have to disagree, and there's nothing wrong with disagreeing. You might be right, actually, but I do have reasons as to why I disagree, and I'll let you know what my reasons are. So first of all, for me to answer that question, I'd like to look at an international convention. It's still not yet into force, but it gives an idea of what the status of customary international law is. And it's the Vienna Convention on the Law of Treaties, not the one that we always talk about, but it's the one between states and international organizations, or between international organizations themselves. And it was drafted in 1986. Egypt actually signed that convention, hasn't ratified it yet. We're 4 ratifications away from it coming into force, so it still gives a sense of the potentially binding nature of this convention in the future. And this is how it interprets a treaty, if I manage to get to the page. So can you all see, or is the font too small? Too small?
Maybe if you put it on slideshow, like, so it gets a bit bigger.
I'm not very tech savvy, Usha. Can you help me with that? Oh, here it is. Is it better?
Better, or is it still too small? That's as good as it
Feel
comes
free to
up.
all sit
Yeah.
like right here in
Come
front
forward.
of me. No problem. No pressure. So the Vienna Convention on the law of treaties between states and international organizations defines a treaty as follows. It's basically an international agreement governed by international law and concluded in written form. So it is a written instrument between a state and an organization. And I'll just jump into the last paragraph, and it says, whether that agreement is embodied in a single instrument or in two or more related instruments, whatever its particular designation. So for all that matters, you can call it MOU, but if there's an intention to be bound, then it's more likely than not the case that it is a binding treaty. So that's the first argument. So in addition to that, there is an ICJ opinion or judgment actually in 1994 on the border delimitation between Qatar and Bahrain. And one of the issues that were discussed were whether or not meeting minutes constituted an agreement, a binding agreement. And in the end, just to get to the point, the court ruled that if there was an intention or it was obvious from the circumstances that it was a binding agreement or that the parties of the two states intended to be bound, then meeting minutes can constitute a treaty or an agreement. So I just decided to have a quick look at the MOU and what it said, just to get an understanding of whether or not it constituted a treaty or at least a binding agreement. And I noticed about 4 or 5 issues that may help me convince you that it is a treaty. So first of all, it was based on on 2 constitutional declarations of 1953. Usually when you see a law in Egypt or a treaty, there's the preamble, and there's usually the typical words that are inserted in a preamble. Surprisingly, they actually do mean something. And one of them was a reference to the Constitutional Declaration of 1953. There were 2. There was one in February and one at the end of the year, around June, I think. And the one in February actually refers to the right of asylum. In Article 5 of that Constitutional Declaration, and I believe, and I may be wrong on this point, although I doubt it, it's the first reference in an Egyptian constitutional document to the right to asylum. That reference was replicated in subsequent constitutions. There was Article 53 of the 1971 Constitution, and there is also an analogous reference, I think it's in the 90s, 93 or 94, of the current Constitution that refers to the right to asylum. So first of all, there is that reference to a constitutional document that pushed the government to enter into that MOU. So that's one thing. The other thing is that the MOU was entered into following receipt of the opinion of the Egyptian Council of State, Majlis al-Dawla. And typically, when Egypt enters into international agreements, more specifically, because I work on this issue, concession agreements involving natural resources, there's always reference to Majlis al-Dawla, the Conseil d'État of Egypt, getting their approval and comments on previous drafts before the drafts turn into a binding legally binding document. The MOU went through cabinet's approval. So the cabinet went through the hassle of convening, going through the document, most likely making changes, and then approving it. So all these formalities are actually fairly similar, albeit not identical, to the ones mentioned in Article 151 of the current and last Egyptian constitutions, dealing with international agreements and the process of turning them into binding documents that are binding on local courts and Egypt in general. And finally, and I know it sounds a little trivial, but actually is not, is if you look at the Arabic version of the MOU as published in the Egyptian Official Gazette, it's referred to as Ittifaqiyya, which in Arabic, if translated, means treaty or agreement, and not Muzakkirat Tafahum, which is the literal translation of a Memorandum of Understanding. So all these things taken together, in my opinion, suggest that the MOU is a binding legal document. So why is all of this relevant? I gave this very long introduction. The relevance of all of this is that it actually gives the government a good argument, at least initial argument, that, you know what, UNHCR, we have an agreement with you. You have to abide by the terms of the agreement. Now that is half the story. And the other half is what I will discuss later today. I'll just give you an example. that shows why the MOU is a bit old, and it does need to be amended. We have to look at it in its historical context. Again, it was drafted in 1954. That's almost 30 years before Egypt ratified the Refugee Convention and Protocol. And if you look at Article 1 of the MOU, you see that without prejudice to Egyptian law, and in general, all sovereign prerogatives of the state, the UNHCR is authorized to establish a branch office, thank you, in view of assuring, in the interest of, and that's where it gets interesting, refugees within its mandate, and in agreement with the Egyptian government, etc., to cooperate basically and provide assistance to refugees within UNHCR mandates. Now, what is UNHCR's mandate? That's also important to consider, because it is an evolving definition, starting with a statute. So the first thing we do is that we look at the UNHCR statute and look at the which was drafted and issued in 1950 pursuant to General Assembly Resolution 4285, Roman letters. And the definition of refugee in the statute is basically divided, it covers two categories of people. The first category of people were people who were granted refugee status pursuant to earlier regimes, and I could mention, which is explicitly mentioned, the International Refugee Organization that was established post-World War II to care for refugees resulting from World War II. But then there's the second definition of refugee in the statute, which is those fleeing persecution for, or fearing persecution for race, religion, nationality, and political opinion. Full stop. Do you see a problem with its definition? Correct. So if you look at the statute back in 1950, and at the time Egypt ratified or signed the MOU, was that you'll find that its scope is it's not a lot, but it is narrower than the definition of refugee in the 1951 Convention and Protocol, because it excludes, implicitly rather, the membership of a particular social group, which I know is an extremely difficult thing to understand. There are loads of guidelines, and I can assure you that the majority of practitioners, be it lawyers or even UNHCR staff, cannot really wrap their heads around that definition. But it's still a category of people, and it could potentially apply to a large category of people and who are denied protection under the statute, at least back in 1950 and 1954 when the MOU was drafted. As I said, the UNHCR statute or mandate can be extended. It can be extended by virtue of General Assembly resolutions. What I would argue is that actually when a country signs or ratifies the Refugee Convention and UNHCR conducts RSD on that specific country's territory, the definition of UNHCR mandate by default would include members of a particular social group. And that is the case of Egypt. So even if there's a reference to UNHCR mandate full stop in the MOU, if you adopt a dynamic interpretation, given the facts and changes in Egyptian law, then by default it would include members of a particular social group. And the reason why I'm saying that is Article 35 of the Convention, which says basically that UNHCR has the duty to supervise the application of the provisions of the Convention. So once Egypt becomes a party to the Convention, regardless of what's stated in the MOU or what happened back in 1954, protection extends automatically to members of a particular social group. Now, that is really the easy part. This is the introduction. I think the main problem with the MOU lies in Article 2, because it really has no connection to what happens in Egypt in 2015, definitely not in 2003 through 2010. And if you look at Article 2, Here it is. Can you read the article? Because that's actually very important. It will be helpful if you can read it. Folks at the back, can you read it? Okay. Just to summarize the article, for those who couldn't read it, there are three main issues, three main problems, or general problems that I have with this article. First one is that UNHCR will conduct, the role of UNHCR would include conducting RSD on behalf of the government, while the government's duty is really restricted to issuing residence permits to refugees. Yellow and blue cards nowadays. That local integration is not an option. If you look at Article B and C, 2B and 2C, these are the ones that I have more serious issues with, is that they exclude local integration, which is one of the durable solutions found in the Refugee Convention. If not the ideal one after, of course, voluntary, and I would repeat, voluntary repatriation. And then the other one is that the Egyptian government will not be financially responsible for refugees, but should allow welfare societies to assist refugees. This is all fine, provided you can register NGOs to provide assistance to those refugees. Last time I checked, which was right before this presentation, that this is not the case in Egypt. So all of this could have made sense back in 1954 when Egypt signed the convention, because it was not a party to, when Egypt signed the MOU, because it was not a party to the convention. It showed good intentions towards refugees and providing them with certain rights. However, when Egypt became a party to the convention, this is where things should have changed. I would argue that to really stick to the words of the statute and Article 35 of the convention, is that the moment Egypt became a party, Egypt should have started conducting RSD, leaving UNHCR with the role of supervising the application of the convention, as indicated in the convention. Now, I appreciate in practice it's difficult and there's always a gap, but I'm just raising questions here, and I know some of the issues I will raise are rather controversial, and we'll have a heated debate about this later today. But this is my contention. So as a result of that, the terms of the MOU stopped reflecting the reality of refugee law and how it should be applied in Egypt the moment Egypt ratified the convention. It was published in the official gazette in 1980. So for about 35 years now, Egypt should have been conducting RSD, or at least maybe started later, but steps should have been put in place back in 1980 to allow the Egyptian government to conduct RSD. Now, Usha told me I should move a bit faster, so I'll have to jump to skip some parts of the presentation, but I'm happy to discuss this in a bit. But there's one issue here I'd like to discuss, is Articles 2B and 2C. Again, the ones that exclude local integration. And they do not reflect the commitment that Egypt made when it ratified the convention. And I'll tell you why. Everybody talks about the reservations, the 5 famous reservations that Egypt made to the convention. In fact, regardless of what happens in practice, which has nothing to do with the reservation, actually the reservations do not prevent refugees from locally integrating in Egypt. And I'll tell you why. The first reservation deals with Article 12.1, personal status. Now, this is actually not a discriminatory measure. This is in line with Egyptian law, because under the Egyptian Civil Code, non-Egyptians who are married to each other, who are undergoing a divorce or having a custody battle or anything family law related, are bound, or the Egyptian court is bound to uphold the party's law. So when two foreigners are married to each other and they go to an Egyptian court, the Egyptian court does not apply Egyptian law. It applies foreign law, regardless of the law. That's subject to another discussion. And the source of all of this is, in my opinion, found in the Ottoman millet system that has existed for more than 200 or 300 years. So this has nothing to do with refugees. It's actually meant to allow refugees to apply their own laws when it comes to marriage and divorce and custody. So that's the first reservation. The other 3 or 4 reservations, they're found in the welfare chapter of the convention. They're not about local integration, because if you look at articles such as 34 dealing with naturalization, Egypt didn't make a reservation to that article. Fine, it's difficult to apply it in practice, because to become Egyptian you have to live for 10 years, you have to speak the language, you have to have shown evidence of, or an effort of trying to locally integrate, but the option is there. It's not easy to apply, but the option is there. So, and other articles as well. Article 15 dealing with the rights of association, Article 17, 18, 19 dealing with employment, Egypt didn't make reservations to those. So even when you look at the government's behavior, at the time it ratified the convention, it did not wish to exclude refugees, or at least if the government claimed that it wanted to exclude refugees, you can argue against that, because you look at the actions of the government back at the time, and there were no reservations to the most important articles dealing with local integration. Reservation on social security, I can tell you, the majority of Egyptians don't have social security, but they locally integrate. So that's one issue I wanted to add. So Articles 2B and 2C dealing with these issues, what I would do, I would add to the MOU an Article 2B1, for example, or 2C1, explicitly mentioning local integration, just to at least reflect Egypt's obligation under the convention. So that's one issue I wanted to mention. So I want to move to UNHCR a bit. So I've been speaking about the government, and again, I appreciate that UNHCR is filling a huge gap, partly because at some point the Egyptian government at the time just left all responsibilities to UNHCR. Emails were being sent, no responses were being received. So it is difficult to try to stick to the law. I only have 5 minutes, so. Okay, so I'll just speak of 1 or 2 things, and then perhaps cheat by saying what I want to say while I answer your questions. Yeah. So, okay, so I'll speak very briefly of the OAU Convention. So Egypt ratified the OAU Convention in 1992. UNHCR applied it in 2003. I don't understand why it took 11 years before UNHCR started applying the OAU Convention. Now, it's definitely, I'm speaking fast, so if I do, let me know. It's definitely a noble thing to do. But every good thing or good deed does or could potentially have negative repercussions. The result was, between 2003 and 2004, the number of refugees applicants accepted or who were granted refugee status increased by 60%. Now, this caused a huge problem. First of all, Article 2D speaks about UNHCR assisting refugees or providing resources to assist refugees. Obviously, when the number of refugees increases by more than 50% and your resources remain unchanged, it becomes very difficult for UNHCR to provide assistance, or at least the quality and quantity of those services would have to decrease. That's the first question. The second one, which unfortunately I don't have much time to speak about, but that's, I think, the more important one, is the issue of resettlement. Most resettlement countries are Western states. Actually, at some point, Burkina Faso was one of the resettlement countries, but it wasn't taking refugees from Egypt. But the majority of resettlement countries, you know, there's a classical 3 or 4, United States, Canada, some Scandinavian countries, Australia, New Zealand. Well, these countries are not a party to the Refugee Convention. So, I'm sorry, to the OAU Convention. So this created a problem because they also did their own investigation of who qualified as a refugee under their own legislation. And the majority of those who were accepted under the OAU Convention, many of whom were Somali citizens, did not qualify for resettlement simply because those resettlement countries did not accept them. So it's not a UNHCR problem. it's a resettlement states problem, but it resulted in an increase in the number of refugees found on Egyptian territory. I would say the area where everybody was wrong, including UNHCR and NGOs and the Egyptian government, is that conveying that message and explaining these details to refugees just wasn't there. And I remember, I used to work at ANERA at the time. We used to get complaints on a daily basis from refugees, why am I not getting resettled? No matter what we would say, they couldn't get it because it wasn't coming from an official source. So this, of course, led to the sit-in, the famous sit-in in 2004-2005, which ended violently with the death of, I believe it was 28 refugees and a couple of, I think, 3 to 5 Egyptian security guards. So there's a large number of deaths, partly because, or to a large extent because, there was very bad communication between those in charge of making major decisions and the refugees. I think I have to wrap it up. I have a lot to talk about. I wanted to talk about the decree in Egypt and why Egypt does have the resources to do RSD. So if somebody would like to ask me that question, that would be great. Thank you.
Okay. Thank you very much, Tarek. There are a number of issues that have been raised already, and I am sorry to cut you off, but I just wanted to make sure that we had enough time to interact with you, and I hope that you can bring up additional issues as we talk. I have lots of questions, but I'm going to save them and force myself to shut up and open the floor to you guys. Anyone want to start us off? Yes. No, it's not on.
Does it work now?
Yes.
Yeah. Okay, the first question is, I'd like to know your opinion about the concept that resettlement is not a right. So if international protection is a right, and in many cases this is not effective in Egypt, how could you justify that resettlement subsequently is